For the record, I am the flesh and breathing man.
All right. Well, I'm glad you're breathing. So,
For the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion. I need to know the jurisdiction this court is operating under.
so have a seat. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat.
If I don't come here, warrants will be placed, which I will be kidnapped and held hostage, and I do not want that.
Mr. Casanova, in the human flesh, I'm going to stop you right there. And I want you to hear me clearly.
All right, guys. Today we've got a sovereign citizen going up against Judge Boyd. But this one feels a little different. Instead of shutting everything down immediately, Judge Boyd is taking a completely different approach. She's meeting the arguments with patience and calm, almost like she's trying to defuse the situation rather than escalate it. And honestly, I'm kind of here for it. Rather than getting pulled into a back and forth, she's methodically addressing each claim, staying composed, and letting the record speak for itself. It's a reminder that sometimes the most effective way to handle these courtroom moments isn't force. It's steady control and clarity. You can tell she understands exactly what's happening and isn't rattled by it. That kind of strategy can be surprisingly powerful. Let me know what you think about Judge Boyd's approach while you're watching. Is responding with patience the best way to handle sovereign citizen arguments, or should judges shut it down more aggressively? Let's dive in and see how this plays out.
Hello. How's it going?
It'll be better.
All right. So my understanding, you want to represent yourself? All right. You're more than welcome to represent yourself. But here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial, and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules, so let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I'm the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me. There are some clarifications I do want to.
All right, so just 1 second before we get to that. Have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
So we're back on the record in 2024 CR 2974. State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for. So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
Oh.
At some point, you almost wonder whether there should be a better screening process for self-representation. not to block anyone's rights, because the Constitution absolutely guarantees the right to represent yourself, but to make sure defendants actually understand what that means in reality. Courts already do something similar. Before allowing someone to proceed pro se, judges typically conduct what's called a competency or waiver of counsel inquiry. They make sure the defendant understands the risks, the rules of evidence, and the potential penalties. The court can't force someone to be a good lawyer, but it can make sure they're making an informed choice. The challenge is balancing two things: protecting the defendant's constitutional rights and maintaining an efficient courtroom. You can't create a belief test for legal arguments, even if those arguments are unconventional. The system is built to allow people to speak, even when what they're saying doesn't ultimately help them. And that's the part some defendants misunderstand. Simply declaring that laws don't apply to you doesn't remove jurisdiction. Courts operate on established constitutional principles, statutes, and precedent, not personal declarations that it's frustrating to watch when hearings drag on over arguments that have already been rejected countless times. But the structure is there for a reason: fairness, even when someone is making a mistake. What do you think? Should courts tighten the standards for self-representation? Or is the current balance between rights and efficiency the right approach?
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness, you need surgery, and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right, Norma, get someone from manage to sign counsel here, please. All right, just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right. So let the record of the court show that I, Hector Casanova
Just one
Jr.
second.
We're
just one stop.
Yes, sorry.
All right, we're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action.
It really feels like he's making things harder for himself with every response. The judge clearly explained the charges on the record, and instead of engaging directly with that information, he keeps circling back to points that don't seem to address the actual allegations. At some point, that strategy can backfire. Courts rely on clarity. If a defendant appears evasive, inconsistent, or unwilling to acknowledge what's being discussed, it can hurt their credibility. And credibility matters, especially when you're representing yourself. Now, it's important to be careful with assumptions. There's a difference between misunderstanding the process, intentionally misleading the court, and simply being unprepared. But if someone knowingly makes false statements under oath, that can cross into perjury, which is a serious offense on its own. What stands out here is the contrast between the judge's straightforward explanation and the defendant's continued resistance to engaging with it directly. Whether that's a tactic, confusion, or something else entirely, it's not strengthening his position. What do you think? Is this confusion, strategy, or self-sabotage?
Furthermore,
let me
let the
stop you.
record also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment. In the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the Admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from managed assigned counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent. I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under. Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under
All right, I'm going
Admiralty or military
to counsel.
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for managed assigned counsel, period. That's it. So have a seat. Managed assigned counsel will come over. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat. Thank you.
I'll be honest, I'm usually skeptical of what people call soft judging, especially in cases involving sovereign citizen arguments. Sometimes it can feel like too much patience just drags things out. But this feels different. Judge Boyd isn't being soft. She's being strategic. Her calm, controlled approach seems intentional. Instead of escalating or reacting emotionally, she's letting him talk, carefully processing each answer, and responding in a way that builds the record. That kind of composure can be far more effective than raising your voice. What makes it interesting is that he appears confident, like he thinks he's steering the conversation. But from the outside, it looks more like she's methodically guiding the hearing exactly where it needs to go. By staying measured, she avoids feeding into confrontation and keeps control of the courtroom. Sometimes the smartest move isn't force, it's patience. What do you think so far? Is this the best way to handle arguments like this? Or would a firmer, faster shutdown be more effective? Let's dive back in and see how it unfolds.
we have talked.
Mhm.
I've informed him that I'm here, to help him in whatever he needs help with.
Mhm.
Um, he's going to consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay. All right. And so you'll be appointed as standby
Yes.
counsel then?
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing. So,
All right. We're going to go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. Yes. All right. So, Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
Yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right. Who threatened or coerced you to come to court?
The county of Bear, Texas.
How so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date, and you can accept the state's offer or come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date, and then you'll sign it. Mr. Bonk will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome, and thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator, and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
I don't really understand the smiling here, given how serious the situation is. That kind of demeanor can come across as odd. Maybe it's nerves. Maybe it's overconfidence. But in a courtroom setting, body language matters. Then he asks about moving the court date, and that definitely changes the tone. On one hand, requesting a continuance isn't unusual. On the other hand, if it looks like a delay tactic instead of a legitimate need, judges tend to see right through it. Courts don't appreciate unnecessary stalling, especially when the record already shows multiple opportunities to address the issues. What stands out to me is the contrast. The judge is steady, controlled, and methodical. He seems relaxed, almost casual. That imbalance can be risky. Confidence is one thing, but underestimating the seriousness of the process is another. The judge already gave him chances to clarify and adjust his approach. Whether he takes those opportunities seriously is up to him. But if he keeps going down the same path, the consequences are unlikely to get lighter. That I will say this. Judge Boyd handled it impressively. Calm, sharp, and fully in control the entire time. That kind of courtroom presence makes a difference. What did you think about how she handled this one? Was her calm approach the right move? Drop your thoughts in the comments. I always enjoy reading them. And if you like courtroom breakdowns like this, don't forget to like and subscribe. Thanks so much for watching. Take care, everyone.